Well, good afternoon, everyone. Good afternoon, everyone. Make sure we're still all alive and well, okay? My name is Ebony Nelson. I have the honor of serving as Dean of this magnificent law school, and on behalf of the University of Connecticut School of Law faculty, staff, students, and alumni, I welcome you to this very special event honoring our very own Professor Julia Simon-Kerr and her appointment as the Evangeline Starr Professor of Law. I extend a special welcome to Professor Simon-Kerr's friends and family, including her mother, Miss Virginia Kerr, and her husband, Mr. Florian Ederer, who's with us today. Thank you both so much for being with us. I thank all of you for attending this evening, and I ask that you please join me in thanking our amazing Associate Dean for Faculty Development and Intellectual Life, Ann Daly, and our wonderful events, ITS, catering, and facility staff for organizing and facilitating this lovely event. Thank you all. This evening is our opportunity to come together as a community to express our appreciation for Professor Simon-Kerr's role at UConn Law as a phenomenal teacher and scholar. The Evangeline Starr Professorship was created in recognition of Judge Evangeline Starr, who was a trailblazing attorney and jurist. She was the first woman to graduate from the University of Washington School of Law and the second woman to serve as a judge in Washington State. Judge Starr's judicial career spanned 29 years. She first served as a justice of the peace and later as a Seattle District Court judge. Judge Starr was active in many civic organizations and was a strong advocate for equal rights for women. She served on the Governor's Commission on the Status of Women and was instrumental in establishing the Seattle chapter of the National Organization of Women, which was actually organized in her chambers in 1970. After hours, I actually read. It was after hours that she did that. It is fitting that we hold tonight's inaugural lecture here in the reading room, located in the William F. Starr Hall. The professorship is supported by the William F. Starr Trust, which was established by Judge Starr by her request in honor of her brother, who served as a professor here at the law school. Throughout Judge Starr's life and career, she was committed to excellence and the administration of justice. The Evangeline Starr Professorship is a testament to her legacy as it recognizes promise, achievement, and excellence in scholarship. As a leading scholar of evidence, Professor Simon-Kerr is so very deserving of this honor. A graduate of Wesleyan University and Yale Law School, she joined the law faculty after 2 years as a Bigelow Fellow and lecturer in law at the University of Chicago Law School. Since joining the UConn Law faculty 11 years ago, she has proven to be an exceptional educator, both inside and outside the classroom, as evidenced by her receipt of the Perry-Zirkel 76 Distinguished Teaching Award in 2021. Her outstanding scholarship in the areas of evidence, moral turpitude, and educational adequacy have been cited by judges and justices throughout the country. She is also a giving and engaged colleague whose dedicated service to the law school and broader community helps to advance our mission and goals. As founder and co-chair of the Prior Conviction and Impeachment Reform Coalition and co-chair of the annual Evidence Summer Workshop, Professor Simon-Kerr plays an instrumental role in improving our criminal justice system and supporting educators and scholars who are committed to doing the same. Julia, on behalf of your family, friends, and colleagues, I congratulate you on this wonderful achievement, and I thank you for your many contributions to UConn Law and beyond. Not only have you made the law school better, but like Judge Starr, you have also advanced the administration of justice through your work. Congratulations, and thank you so much. I now invite Professor Kyle Brennan Marquez to provide remarks about Professor Simon-Kerr and her work. Thank you.
Hi, everybody. Thank you for inviting me to do this. It's a great honor. I was thinking about what to say, and it occurred to me that the awesomeness of having Julia as a colleague is so overdetermined that it's like hard to figure out what I wanted to distill this down into talking about, because there are many, many things I could focus on. I'm going to talk a little bit about two of those things. One is just what it's like to have her as a colleague day in and day out, and what a pleasure that is, and the other is about her scholarship, which of course you'll hear much more about from her as well. So in terms of having her as a colleague, I thought, there were a bunch of stories that, I was kind of thinking about. One that was really vivid in my mind, I remember when it was my first year here, 5 years ago or so, and I was asking her about norms about going to the faculty workshop, like how many people go, how frequently, like, will I be, I didn't have tenure yet, I was not familiar with the place, will I be dinged if I don't go, like all this kind of stuff. And she said, oh, I try to go to all of them, but not everyone does. I try to go to all of them. Well, I find out a few months later, and then it's corroborated over the years every single time, that what that means is that she's literally never missed a faculty workshop, except in case of like exceptional childhood illness of children or something like that, right? So she's there, and she shows up in this robust way at the faculty workshop, but also just writ large. Like when I said, hey, I want to organize a reading group about law in dark times, and we're going to read a combination of classical legal theory and Kafka and Harry Potter, and maybe there's going to be a film, and we can have it was all over the place in a lovely way. It was kind of extracurricular or supererogatory, and she said, sure, I'd love to run that with you on top of everything else that I'm doing, So these are the sorts of things that I think mark her contributions as a colleague. And not least of all, I can say at a very personal level, I'm sure others have had similar experiences, but I find myself having been hired 5 or 6 years ago to teach a combination of constitutional law and policing courses, now teaching primarily evidence and civil procedure, which are her courses, and which with apologies for the candor to the students here, we're pulling back the veil, I didn't really know that much about before I started teaching them. And it is not an overstatement to say that there's a large swath of students, some in this room and some having gone off to greener pastures, who know about particularly the rules of hearsay solely in virtue of Professor Simon-Kerr's, or Julia's help to me as the instructor. I wasn't exactly sure how to talk about her scholarship, because when I tried to organize my thoughts, there was actually a kind of a melancholy note to it for me, because I think the strengths of her scholarship and the way that she is engaged with the law are so rare in our profession. We have a profession that is sort of holds itself out to be the kind of living successor group of the Socratic tradition, and is just falling short of that all over the place in lots of ways. Much legal scholarship is sort of glib. It endeavors to take on big, enduring puzzles, but it does so in a way that reduces them to kind of flat answers that really don't have much legs in practice or in theory. Or it's not glib, it really does wrestle with things, but it's so pretentious and convoluted that it just makes no contact with the actual human institutions that it's trying to sort of describe and perfect. And so I think about somebody like Julia as just the paradigm case of avoiding those pitfalls, of actually doing work that is sort of tenaciously and totally unpretentiously interested in wrestling very hard questions to the ground and figuring out what the answers to those questions mean for the actual institutions that we and other normal folk have to interact with on a day-to-day basis. And so I can think of no higher praise than that. And I think it is befitting of the subject that she has taken up, which you'll hear more about from her, but as I take it, is essentially, how do we want to configure a system where we are charged as citizens, it is our duty in some ways to stand in judgment of one another when the time is right, when we are called to do that. And that's an incredibly uncomfortable thing. And there's a lot of people who have said that we should try to basically just take a risk-averse sort of prophylactic approach to that and try to remove all the human infirmities that attend to that process. Try to make it so that when we stand in judgment of one another, we can at least say that we're not indulging the worst kinds of bias and vindictiveness and all the other kind of dark sides of the human mind and psyche. And Julia is not satisfied with that. Of course, she wants those things, but she also wants the system to express and try to nurture the aspirational sides of humanity as we have to stand in judgment of one another. And as we are sort of called to the duty of trying to figure out when judgment is appropriate and when it isn't in a community of people who are sort of co-equal in a democratic order and who are just as frail as one another. So I think that subject really requires sort of deep, ambivalent, and complex responses. And Julia and I know from experience, having gone to lots of evidence conferences and how together, once I learned the subject, I decided to write in it, and I go to conferences with her. That's just not the norm in our little subfield or writ large. There's a lot of easy answers. Julia herself has accused me, rightly in many cases, of trying to develop too easy answers to hard problems, and I'm sure I'm not alone on the faculty in having had that experience with her as an interlocutor, and I can just sort of, again, think of no higher praise than that. So I'll leave it there. I'm really excited to hear your lecture. I'm sure everyone else is too, and congratulations.
Wow, that was, I feel like we should just stop there. That was awesome. Thank you, Ebony. Thank you, Kyle. It's such an honor to get to receive this Evangeline Starr professorship, both because of her, just incredible history, also because the previous holder of this chair was Dean Daly, who I also need to thank for all her work organizing this, and I'm excited to succeed her. And also because, let's be honest, being the Starr professor goes without saying that is the best. I really want to thank all of you for being here, especially my students and my former students. It's so nice of you to come. And I want to thank my colleagues for really giving me the freedom to pursue the questions that interest me. And I always think of Stephen Wilf's expression, tenure of the mind. And I have really felt like I have that here. And it's thanks to all of you. And last but not least, thanks to my family, and especially my mom, who has never turned down a request for editorial feedback. So again, it's a real honor to be given space to reflect on my work in this way. And I thought I'd use this time to talk about some of my work thus far in the context of a question that I have been thinking about a lot recently. I'll start with some big picture thoughts and then try to tell some stories to keep us all awake, to illustrate also what I'm thinking about. So here we go. A large part of my work over the last 15 years or so has in some way revolved around two observations about evidence law. First, the evidence system can shape how we understand what we know and who we recognize as having knowledge. It both disseminates and holds constant cultural beliefs. And second, somewhat in tension with this, evidentiary rules and principles can also have a progressive ability to help us identify when stereotypes are being substituted for facts. Evidence law can respond to evolving ideas, and it can be used to reject causal connections or whole classes of evidence that it once embraced. Studying evidence is an enterprise in logic, yes, but it's also a way to see the fundamental indebtedness of what we often call logic to the social context in which evidentiary logic problems are being asked and answered. For me, this second aspect of evidence law, its dependence on social beliefs, has always been its most interesting feature. Evidence law can tell us about ourselves. And if we study it critically, we can see how it reflects and helps to perpetuate many of our worst failings. But at the same time, the U.S. evidentiary system is constructed on a foundation that is fundamentally progressive. The concept at its heart, relevance, and its close ally, the requirement of balancing probative value against the risk of unfair prejudice, are flexible and evolutionarily inclined. They hold great promise in their ability to help us recognize voices and viewpoints that have been silenced. Through them, we have the ability to reject dominant narratives about cause and effect in favor of truths long understood by the marginalized. But the promise that our evidentiary system holds out is not realized often enough. And this, I think, in part reflects interpretive choices that are seen as procedurally inexorable, but which are actually substantive. Much of my work has argued in one way or another that we should recognize these normative choices for what they are: rules or rule applications that cloak oppressive substantive judgments in the mantle of fixed evidentiary logic. Many evidentiary judgments are not the inevitable product of logic, but are instead socially constructed. This evening, I want to highlight an important question that I think follows from recognizing certain evidence judgments as normative choices, and that is whether we need a normative principle to guide evidence decision-making. This question has, to my knowledge, rarely been asked by evidence thinkers. As a procedural field, the paradigm in evidence has been to assume a purpose, such as truth-seeking or efficiency, and assess how well certain rules or doctrines are able to accomplish those ostensibly neutral goals. But evidence law is not unburdened by value judgments, and I think we need to focus more in the field on how well our rules and doctrine can accommodate concerns about inequality and justice. In fact, one possibility I've been toying with is that maybe evidence law should be understood to have not just the ability, but the obligation to question dominant narratives and to avoid applying evidentiary principles in ways that perpetuate subordination. In other words, I'm wondering whether evidence law should have an anti-subordination orientation. What I mean by anti-subordination here is an idea that Owen Fiss, my civil procedure professor, first wrote about in 1976 in the context of the Equal Protection Clause. Fiss argued that the legal system may not aggravate or perpetuate the subordinate status of a specially disadvantaged group. As we all know, equal protection doctrine did not develop in this direction. Instead, it focuses on classification and differentiation. But Fiss wrote that we should care about the way that institutions and practices enforce the secondary social status of historically oppressed groups. Recently, scholars have brought this lens to bear on areas like criminal law reform and even administrative law, and I've been thinking about whether it might have something to offer evidence as well. In the rest of the talk, I'm going to offer 3 examples of normative choices we see in evidence law. I'll try to bring us down from this abstract introduction and tell stories. So first I'll talk about some of my earliest work on impeaching women with evidence of unchastity. This gives an example of how courts, in this case applying common law evidentiary rules on impeachment, can embrace problematic social assumptions filtered through those rules, but also use those very same rules to reject those assumptions. Second, I'll talk about recent work by David Sklansky tracing the history of our strict prohibition on hearsay to a Supreme Court case in which an enslaved woman sought to prove that she was actually free. Again, the example shows the court facing a superficially procedural choice, but also how impossible it is to separate that choice from the social context in which it was made. And finally, I'll talk about the rules on character evidence, which were solidified with the passage of the Federal Rules of Evidence in 1975. These rules present judges with a propensity prohibition that works very well to shield certain people from being judged on the basis of their characters, and does very little to shield others. And here too, the choices the rule drafters made and the way these rules have been applied suggests why we need to meet the normativity of the rules with a theory of interpretation that is able to address it. So first to credibility, which, as many of you know, I'm surprised Kyle didn't mention it, is a topic I might actually think too much about. But the fun part of starting here is that I get to tell a story about how I got interested in studying evidence in the first place. So when I got to law school, I had recently been reading and thinking about Adrienne Rich's essay on lies, secrets, and silence, and particularly a claim she makes in it that truth has not been considered important in women. Rich writes that virginity, chastity, and fidelity to a husband are the qualities that form the substance of a woman's moral integrity, but that truth-telling itself is not a part of women's honor. It didn't take me long to notice that law school involves reading case after case, suggesting that there is a truth, and juries and judges are finding it, and witnesses are telling it or not telling it. And this truth makes up the mythical center of the trial. But what does the law do with the social construction of truth? For example, how does it address the ways in which truth has not been considered important for women? To dig into this question, I eventually made my way to evidence law and the early days of impeachment jurisprudence in this country. As you'll see, understanding this body of law required an awareness of the cultural context in which the courts were operating and the way they interacted with it. And looking at that context reveals a complex social attitude towards women and truth. Many of us are familiar with special standards for women, which also varied along lines of race and socioeconomic status. White middle-class women, for example, were simultaneously on a pedestal, revered for their moral integrity, and they were also in a cage. They were forbidden from voting or otherwise participating in public life. But what I didn't learn in my history classes is that the culture also made truth-telling itself problematic for women. For example, Rousseau wrote that a woman's honor does not depend on her conduct alone, but on her reputation, and no woman who permits herself to be considered vile is really virtuous. At the same time, he wrote that reputation is the grave of man's virtue. Rousseau argued that women's focus should therefore be on preserving the trust of their husbands and their reputations for virtue. None other than Mary Wollstonecraft pointed out that this logic means that in the kind of imperfect society in which we live, truth-telling and virtue will not necessarily be aligned. Women might need to lie to prevent their reputations from being ruined. Rousseau and Wollstonecraft helped reframe Adrienne Rich's claim that honesty in women has not been considered important. In one sense, chastity and credibility were one and the same thing in the popular imagination. And in that sense, honesty was of paramount importance for women. At the same time, even a chaste woman could be expected to lie in order to keep up appearances, creating another way in which the appearance or reputation for virtue made truth-telling potentially problematic for women. This set of cultural assumptions appears in the language of earlier opinions. One of my favorite examples is from Adkins Children's Hospital, which was a Lochner-era case striking down special contract protections for women. Justice Sutherland argued that both men and women would benefit from a minimum wage, so if a minimum wage was unconstitutional for men, it would be for women as well. But his choice of language encapsulates the different perception of truthfulness in men and women. He wrote, "If women require a minimum wage to preserve their morals, Men require it to preserve their honesty. For women, moral purity and honesty were inextricably linked. But what about evidence law? At least in theory, the courtroom should be a place where we cut away the extraneous social baggage and find the truth. And yet, evidence law has never offered an unmediated path to truth-seeking. As Catherine McKinnon has written, evidence law lays down what the legal system will take to be real. As law's epistemology, the rules of evidence embody assumptions about reliability and credibility and common knowledge. Those assumptions were clearly on display in 1817 when the Supreme Judicial Court of Massachusetts decided a case called Commonwealth versus Murphy. Murphy was a rape prosecution, but the woman the state's attorney sought to discredit was a defense witness who was allegedly known as a prostitute and had borne several children out of wedlock. The defendant's lawyer objected to the use of this evidence to impeach her credibility, but unsuccessfully. The judge directly linked the witness's chastity to her truthfulness, observing that a common prostitute must necessarily have greatly corrupted, if not totally lost, the moral principle, and of course, her respect for truth and her regard for the sacredness of an oath. This argument followed logically from the cultural belief that a woman who is unchaste has lost her honor, and a woman without honor should not be trusted to tell the truth, even when sworn under oath. Because Murphy involved an alleged common prostitute, we might think the opinion was really about the perceived immorality or illegality of prostitution itself. But the crimes of men were treated differently. As the New York court noted 20 years later in Bakeman versus Rose, it is perfectly well settled, both in New York and in England, that evidence that a person had a reputation for committing crimes, such as being a murderer, forgerer, adulterer, gambler, or swindler, could not be admitted to impeach that witness. I should note that Murphy did have a short shelf life in Massachusetts. The SJC overruled it in 1846, but the case continued to have currency in other jurisdictions for nearly a century. For example, in 1880, Missouri used it to strengthen its own version of the rule that a woman could be impeached with unchastity evidence. In State versus Sibley, which is one of the most quoted early rape cases, the Missouri Supreme Court overturned Mr. Sibley's conviction for the statutory rape of his stepdaughter because the trial court had improperly admitted evidence that his reputation for chastity and virtue was bad. To explain its holding, the court stated infamously, "It is a matter of common knowledge that the bad character of a man for chastity does not even in the remotest degree affect his character for truth, when based upon that alone, while it does that of a woman." In 1913, in another very bleak statutory rape case from North Dakota, State versus Apley, the majority opinion still reflects a belief that a woman's reputation for unchastity is admissible to impeach her. In Apley, a 15-year-old girl had accused her father of raping her when she was 12. Although she was under the age of consent, the court held that she could be asked on cross-examination if she had lived in a brothel. According to the judge, living in a house of prostitution and other such escapades evince a degree of general depravity affecting credibility. At root, the question that all of these courts were answering was whether these women's chastity was relevant to their credibility. And the fact that their answer is so much in conflict with what we might think today shows how mutable ideas about relevance can be. This is important because we have treated relevance as an inquiry that depends on, as Rosemary Hunter puts it, universally accepted generalizations about human behavior that are available to all triers of fact. The belief that a woman's credibility depended on her chaste appearance was one such accepted generalization. If we break down that generalization into its component parts, and yes, we do get to do some logic puzzles this evening, we can see the theory of relevance that led to women being impeached with unchastity evidence depends on at least two generalizations. First, there is the assumed interdependence between a woman's honor and her conformity or apparent conformity with norms of chaste behavior. And second is the generalization that a woman who lacked honor also lacked credibility. In some of my work, I've argued courts often did not need a third generalization, one that says a woman who lacks honor or credibility is more likely to lie than an honorable woman. Rather, this is where we find the fundamental truth in Adrienne Rich's maxim that women's honesty was not considered important. The legal system was largely uninterested in whether women without honor would, in fact, lie. Their failure to maintain a chaste reputation meant they were not worthy of being believed. A similar theory underlay incompetency doctrine, which precluded the possibility that enslaved or formerly enslaved people, and often Native Americans as well, could testify and thereby have credibility in courts of law. But we don't see the unpacking of these logical chains in judicial opinions. Instead, early courts and attorneys invoked common knowledge and reason, both as the basis for their assumptions that a woman's chastity determined her worthiness of belief, and as the reason for leaving behind that assumption. For example, in 1935, Missouri was one of the last jurisdictions to abandon impeaching women with evidence of unchastity. And its Supreme Court did so largely because it concluded that reason favored focusing on evidence of truth and veracity. No new substantive or procedural law impelled this doctrinal change. Rather, judicial reason, which had once suggested that unchastity was acceptable impeachment evidence, now responded to a changed epistemic environment and drew the opposite conclusion. A final point I want to make from this example has to do with how evidence rulings can shape reality itself, creating chicken and egg problems. One question I've been asked when I present work on the historical entanglement between a woman's chastity and her credibility is whether there might, in fact, have been a correlation. Many thanks to the economist spouse over there for that question. Right? Would an unchaste woman, in other words, be more likely to lie? There are two ways to answer this question. First, as I just described, this was not actually the empirical question that fact finders using this elision cared about. Second, the question starts from the wrong premise. The belief system that connects two propositions through the relevance inquiry, or the broader process of proof itself, has the power to create an actual probabilistic connection. If a particular culture discredits people for behavior separate and apart from lying, while still paying some heed to actual lies, those people will be assumed to be lying regardless of their actual words, and will have less incentive to be truthful. Whether they lie or not will not change their chances of being believed. In contrast, people who have maintained an outward appearance that will not in itself be discrediting might be more concerned about being caught in outright lies. Lying is more costly for this latter group, which could make it correspondingly less likely. This suggests one reason why a doctrine holding that women will be disbelieved if they have reputations for unchastity could create the conditions in which those women are more likely to lie. They have no incentive to be truthful because we have already discounted their credibility. In other words, belief systems can be self-reinforcing. creating the probabilistic connections they espouse. While evidence theorists have focused on the risk of error as one way to justify evidentiary regimes, this example shows how incomplete that lens is. The risk of error is a function of baseline assumptions that reinforce certain realities at the expense of others. Similarly, evidence theorists focusing on the intricacies of probabilistic reasoning are missing the point. There is no view from nowhere, and to suggest that probabilistic reasoning will or could ever achieve it is one way to ignore the contingency of knowledge. And this is what has led to my thinking about what guidance we have about how to answer the question of the reference class. How should we approach the fact that normativity will influence what is often passed off as common knowledge or reason? My view is that these questions need to be answered in a way that gives substance to certain principles that are supposed to ground rules of evidence. If we take the federal rules as our model, Rule 102 says that the rules should be construed to administer proceedings fairly, promote the development of evidence law, ascertain the truth, and secure just determinations. So the question becomes, how can we best put fairness and justice at the center of evidence law? And how can we push for this body of law to develop towards centering these tenets? We have tools to strive for this already. Relevance and balancing of probative value are very powerful ones. Looking at the history of credibility impeachment shows how relevance, though, is contingent on social understandings. And at the same time, the relevance inquiry has allowed courts to do amazing things, to reject spurious evidentiary connections, even when they've had a long tenure in the law. So relevance holds the power to incorporate different sources of knowledge into the evidentiary process. Still, judges and rulemakers often seem oblivious to this potential. Questions of relevance and the weighing of probative value are often treated as common law style inquiries, requiring that we ask what judges have thought about it in the past, with the added filter of a judge's own sense of how the world works. But what if we were to add an interpretive principle to guide this weighing of evidence? Could many of what we now see as misjudgments in evidence be avoided if we make more explicit the mandate extended in Rule 102 to apply the rules fairly and to the end of securing a just determination? I'll say more about this in a minute, but first I want to turn to another example. So in a recent article, David Sklansky, who is an evidence professor at Berkeley, traces the history of our strict prohibition on hearsay back to a Supreme Court case from 1813. The case was a petition charging that a woman named Mina Queen and her daughter Louisa were being illegally held in slavery by a man named John Hepburn. The petition stated that Queen's great-grandmother had come to the American colonies from England as an indentured servant rather than as a slave. These cases were not uncommon at the time, and some of Mina Queen's relatives had successfully won their freedom with depositions from people who reported hearing that their ancestor, Mary Queen, had been in England before coming to the United States. The transit through England suggested she could not be enslaved because of English law at the time. The depositions also said she had dressed like a free woman and should have been free. And in Mina's case, she also had new evidence, including a deposition from a witness who said he spoke with Mary Queen and was told she had been born free in Ecuador and then lived in London. At the time, the hearsay rule was not the fixed barrier to introducing evidence from unavailable witnesses to prove the truth of the matter asserted in the statement that many of you are familiar with today. Instead, while hearsay evidence was disfavored and often inadmissible, courts viewed it as potentially proper if better testimony couldn't be obtained. One common example was when proving family ancestry or other ancient transactions, where it would be typically impossible to produce live witnesses. And this is how several of Mina Queen's relatives, as well as many other enslaved petitioners, had been able to win their freedom. But when the Supreme Court heard Mina Queen's case, Justice Marshall decided that the depositions she offered were inadmissible hearsay. Marshall rejected the notion that hearsay evidence should be excluded unless it wasn't possible to procure better evidence. Instead, he held that the frauds which might be practiced under its cover combined to support the rule that hearsay evidence is totally inadmissible. He further added that the fact that the case involved the enslavement of people as property did not create, quote, a legal distinction between the assertion of this and any other right. This example is a counterpoint to the discussion of credibility in a few ways. Credibility is a cultural construct. It's a measure of how believable a person seems to others around them. So it's comparatively easy to see how it can be invested with cultural baggage that seems unhelpful to arriving at a fair, just, or true outcome. If we take an anti-subordination approach to credibility, it might mean being sensitive to the stereotypes that are often embedded in credibility judgments and trying not to reinforce subordinating stereotypes through law. Hearsay is different. Today, it represents, in many ways, the pinnacle of thinking about evidence law as a product of neutral logic that will apply indiscriminately to all litigants without regard to group membership or subordinated status. But part of what Sklansky wants to show in his article is how context-driven the Queen decision was, and how this decision was formative in moving evidence law in the US toward the strict hearsay prohibition we have today. It's not hard to see why we might want a hearsay rule to protect people like Sir Walter Raleigh, who's the iconic example in hearsay teaching, from being condemned to death for treason on the basis of testimony from an out-of-court witness. But it's equally easy to see, if we ask the right question, why certain questions of ancestry shouldn't be decided without considering hearsay statements from those who are no longer alive or available. And in considering today's hearsay rule, it's important to understand that part of why judges developing evidence law made the rules they did was because of the status of the litigants in front of them. Sir Walter Raleigh was an aristocrat, and Mina Queen was a Black woman being held as a slave. If Justice Marshall had been making evidentiary judgments in keeping with an anti-subordination principle, rather than through the prism of a slave-holding society, Mina Queen and her daughter might have been able to join their relatives in winning their freedom. And beyond that, the hearsay rule itself might look very different today. Instead of an absolute prohibition on hearsay, coupled with ever more complex exceptions to the rule, we might have a hearsay principle that could bend when it was impossible to produce live testimony and the hearsay was sufficiently reliable. If we consider which litigants are better able to bring live witnesses to court and preserve testimony, we can see possible anti-subordination benefits to such an approach. Seeing that modern evidence law developed in the shadow of subordination should raise interpretive questions. Today's evidentiary system explicitly aspires to administer proceedings fairly and to the end of obtaining truth and securing a just determination. In light of the history of even our most ostensibly rational rules, it's worth asking whether we can do this without an anti-subordination principle. To put a point on this, if Mina Queen's case were tried today in federal court, Rule 803.19, which I apologize, I do not teach when I teach evidence. There are many, many exceptions. Rule 803.19 makes an exception to hearsay for reputation concerning family history, and it might admit some of the depositions Mina Queen hoped to introduce. But it would not cover one crucial deposition that reported a direct conversation with her ancestor, Mary Queen. To admit those statements under the federal rules at present, a court would need to be persuaded to apply the residual exception to hearsay, which, as my students do know, is very rarely employed. Even were a court to consider using it, it's not clear how they should apply that exception in this case. The exception in the federal rules says only the evidence can come in if it has guarantees of trustworthiness and is more probative on the point than other evidence that can reasonably be obtained. A court could go either way in thinking about the deposition reporting the conversation with Mary Queen. Is it more probative than other evidence? Most likely. But does it have guarantees of trustworthiness? And what about the general judicial norm of avoiding the residual exception? Evidence law doesn't have an answer to these questions. And the way we discuss them often starts from an assumption of rationalist truth-seeking under neutral rules. But evidence law has developed with normativity, and I think it's time to ask if it should be interpreted with normativity as well. If we're committed to fairness and obtaining true and just determinations, we may not be able to do that without correcting for the subordinating nature of our rules. The history of credibility impeachment shows how subjective social hierarchies embed themselves into evidentiary rulings, becoming binding precedent and shaping both future judgments and possibly also our ability to disentangle questions of truth from questions of belief. But it also suggests the power inherent in the relevance principle to make rulings that embrace different subjectivities and reject long-held assumptions. How the inherent normativity in that principle should be used, though, is a question that evidence theory hasn't answered. The example of hearsay suggests there are similar unanswered questions even in the context of the rules that seem least prone to subjective judgment. I want to close with a final example that focuses on how rules can tie us to ways of understanding that make it impossible to remedy systemic injustices being perpetrated by those rules. Here I want to focus on character evidence. Evidence rules don't have a definition for character itself, but these rules are where we enact the principle that people must be judged for their actions rather than their identities. For this reason, the rules generally exclude character evidence to prove action in conformity with that character. In recent work, I've argued that the rules actually do have a specific view of character. This vision is the product of formal rules addressed to prior conduct or character-related testimony, the methods of proof that are permitted, the tacit endorsement of certain applications of the rules, and also what the rules have refused to address. The upshot of these interventions and non-interventions is a system that achieves its stated goal with respect to certain people. Essentially, the propensity prohibition operates from the premise that there is a baseline character, and the rules work for him. Let's call our baseline character Smith. Smith is most often a man and white. He may be an unpleasant character, possibly verbally abusive at home, or to his subordinates at work, disliked by many, but he has no prior convictions. And he can come to a civil or criminal proceeding in relative certainty that the propensity prohibition will shield him from being judged on the basis of his past conduct and generally bad reputation. Smith also doesn't need to worry that his skin, his clothing, or the way he expresses himself will brand him as unreliable, deviant, or violent. Smith is the baseline, and the propensity prohibition works for him. The rules actually work so well for Smith that they have had to be bent in certain circumstances. Let's say Smith is accused of sex discrimination at work. When Smith is brought to account for this, the propensity prohibition may become an essential tool in his defense. Smith, as we've said, looks generic. He's well-spoken. He has been socialized to believe in his own entitlement and to use charm when needed. He denies that he discriminates against women at the office. In contrast, the coworker who has accused him is uncomfortable in the courtroom. She has difficulty answering questions at trial. And compounding those problems, legally, to prove that Smith has discriminated against her, she essentially needs to show that he has discriminated in the past against female coworkers, which will prove the adverse action against her was also discriminatory. Yet, under a correct application of the propensity prohibition, which I should note courts generally don't actually impose, this would be impossible. Smith's past acts can't be introduced to prove action in accordance with what they show about his character. Let's consider another baseline character. This one is a real person named Officer Fisher. Fisher and another officer stopped a car in which William Daniels, a black man, was riding. And by Daniels' account, Fisher proceeded to shout racial slurs at him, slam him against his car, and then physically attacked him with the help of another officer, eventually beating him unconscious. When Daniels sued Fisher and the city and a few other people for excessive force and failure to train, among other things, he sought to introduce evidence of the officer's prior misconduct on the job. Daniels' legal theory was failure to train, but he may also have hoped that introducing this evidence might offset assumptions of good character and credibility that are often accorded to police officers in this country. And he may have hoped to counterbalance the negative character assumptions that would automatically attach to him, a black man who had been the subject of at least one arrest. Yet the court held, correctly under the rules, that evidence of Fisher's past misconduct was inadmissible propensity evidence. The past misconduct evidence, the court explained, might be improperly considered by the jury as proof of the violent propensity and character of the individual defendants. This example, again, shows a propensity prohibition that works well for men in positions of power. It helps ensure that Officer Fisher and others like him continue to benefit from assumptions that police officers are trustworthy and upstanding by excluding evidence that might shake those assumptions. But now let's take another character. Ruiz is also a real person. He was tried jointly in Massachusetts, not that long ago, with his former girlfriend, Dela Cruz, for heroin trafficking. The police found the drug in Ruiz and Dela Cruz's apartment after a search. At their trial, neither defendant testified, and the evidence against them was virtually identical. Both sat and watched the trial without major outbursts or other notable conduct. After the case went to the jury, for deliberation, the jury returned a question. So they asked the judge, "Can we take the defendant's body language into consideration as evidence?" The judge responded as follows: "While not evidence, the jury is entitled to consider any observations you made of the defendant's demeanor during the trial." The jury then convicted Ruiz of trafficking heroin, but acquitted Dela Cruz. Unlike in Officer Fisher's case, where the jury was shielded from information that could create negative assumptions, in Ruiz's case, he was very likely convicted because the jury made assumptions about him based on his appearance, as he sat silently in the courtroom. And those assumptions led them to attribute responsibility for the drugs to him and not Dela Cruz. Still, the judge's instruction that jurors' observations may be considered but were not evidence was not technically wrong. It endorsed the evidentiary bedrock that witnesses' demeanor, unlike other evidence, which must at a minimum be relevant to be admissible, is in some way part of the evidence without any definite rules as to its significance. Unlike the past misconduct of Mr. Smith and Officer Fisher, the propensity prohibition was not intended to address Ruiz's problem. And none of the propensity inferences the jury made in his case are recognized as such under the rules. Instead, the character evidence rules are shaped to shield those who can come to court without fear of negative inferences about their demeanor, without prior convictions, and with the kind of prior misconduct that fits behind a propensity prohibition, tailor-made to shield it. Evidence scholar Ron Allen describes the process of proof as banal, precisely because it reduces to the proposition that a disinterested fact finder reconstructs the past based on all the observational inputs available. And one reason we have rules excluding evidence is, of course, that we are trying to limit some of those inputs. But the rules were made by drafters with their own conceptions of the world. And the character evidence rules reflect a view that certain sources of propensity reasoning are not cognizable under law. Under such a regime, it's clear that those who are best able to conform to jurors' expectations about what a truthful or upstanding person is like will benefit. And those who slot into stereotypical character-based assumptions that derive from their appearance, speech, prior convictions, or other tangible characteristics will be systematically disadvantaged. And it's also clear, as in the credibility context, that these assumptions can become self-fulfilling prophecies because they change the incentives of those who will be subject to them. If we want to give real substance to the notion that we judge acts rather than character, I've argued in recent work, we should reconsider both the rules and the rule makers. But at present, such a reconsideration would proceed without an anchoring principle. Again, I wonder if an anti-subordination principle might be the right place to start in filling that gap. William Twining, one of the iconic evidentiary thinkers of the 20th century and into the 21st, writes that the rules of evidence are a series of disparate exceptions to a principle of free proof, where free proof means ordinary principles of practical, inferential reasoning. In his view, relevance is the obvious bridge between the logic of proof and the rules of evidence. Twining and other evidence theorists have recognized that this logic of proof is contingent upon generalizing from social understandings or experience. But there has been little to no discussion of the fact that that act of generalizing involves choices, and those choices are currently made without the guidance of an interpretive principle. The notion that there is a logic of proof and the idea that evidence is about neutral rationality, even to the point that it's transsubstantive, have obscured the normative nature of evidentiary rules and decision-making. The examples I talked about this evening point to the real choices we face in creating or applying evidentiary rules. Should judges accept that a woman's chastity is relevant to her credibility, as we still do when we impeach women with prostitution convictions? Should the character evidence rules account for the influence of demeanor? Should we be concerned that certain repeat bad actors will benefit too greatly from the propensity prohibition? And was it a good thing that U.S. evidence law followed Justice Marshall's lead in coming to embrace an unyielding prohibition on hearsay evidence? An anti-subordination lens might not only suggest answers to these questions, but it could help promote the purpose and give direction to the development of the evidence rules themselves. If we are supposed to construe the rules to administer every proceeding fairly to the end of ascertaining truth and justice, we need to consider how our rules themselves can change what truths there are to find. And if we want just outcomes, we should question whether importing the power hierarchies in our flawed society into our system of proof leads to justice. And if we want fairness, we should strive to change rules and interpretations that enforce the secondary social status of groups who have been oppressed. Thank you.
A tour de force. Thank you so much. We have time for a couple of questions. I know some people have to run out, but we have time for a couple of questions if there's anyone in the audience that could possibly follow that up. Yes, Anya. Anya has her hand up.
That was awesome. Thank you. I guess I think of what you're doing across these 3 examples, and I guess like across those fields, as in a way shining a light on the way that relevance is not born, it is made, and the strategies or the context that allow for relevantizing something, like to make it into a verb rather than adjective. And so I guess my question based on that and the anti-subordination principle is how do you see a judge relevantizing the things that you think should be newly relevantized? I'm just going to use it as a verb exclusively from now on.
This is amazing. I'm really excited that we have this new word to talk about. How do we relevantize? Yeah, I mean, I think it's not going to be easy. And it certainly doesn't mean throwing out everything that we know about evidence, even though maybe it sounded like I was saying that. But I think it's really paying attention to thinking, asking the question, what does this do with respect to subordinated groups? Is this application, keeping going with a long line of just implementing hierarchical ways of thinking, hierarchical ways of assessing people? Can I depart from that? And, in the examples, it's like the judge in Ruiz's case saying, no, you really shouldn't think about. I mean, that's a controversial, I don't think that would happen here in Connecticut. But saying, you shouldn't be considering that as evidence in a case where the defendant didn't even take the witness stand. But, it's thinking about context more and thinking more broadly than just kind of, well, how do I usually think about these questions of admissibility and what does the precedent tell me?
Any other questions? Peter?
What about if the judge said, yeah, you can do this, but I want to caution you that you may have these biases and it's dangerous territory to be going into. Is that sort of a compromise that allows some flexibility but also allows following the rules?
Yeah, so what, maybe we try to inform juries in response. And I think that's part of it, right? I think these aren't easy questions to ask, and they're really not easy to answer. So it's multifaceted. It's reassessing some of our rules, but then also talking to juries about the things they should be worried about using demeanor for, while also recognizing that how people appear is part of their selfhood, and that's very important. So we don't want to ignore that completely. But, we have a long tradition in law of thinking that engaging in the legal process as jurors or even as litigants is a way that we construct our civil society and our civic society and establish norms. And so I think talking to jurors about these things is a great part of the solution because it's moving our civic enterprise forward when we have those conversations.
Molly?
So thank you so much for this. I was wondering if you could talk about the institutional dimension of this, and particularly in some ways thinking about the myth of objectivity that we have when we think about courts. And I share 100% your, legal realist impulse to uncover the power that's embedded in all of these rules.
But I wonder if you have thoughts on sort of the respective roles of courts versus legislatures in thinking about this, and thinking about the embrace of a normative principle. You know, what would be the roles of these two branches in that endeavor?
Yeah, I love that question. And I think, I mean, evidence is a really interesting place to be thinking about this, because evidence rules are made in so many different ways. And even, you know, in many jurisdictions, they're partly made by courts, they're partly made by legislatures, they're partly made by rulemaking bodies. And so I think it's, you know, especially complicated to think about it in this context. You know, and one thing I've been thinking about is that we need to have more people engaged in this process. And so for that reason, you know, the legislative arena is in theory more equipped to bring more people into the process. I'm not sure that's actually, that would actually happen. You know, this is a very specialized thing, and really hard to imagine lay people coming in to talk about the rules of evidence. Or, but I do think that attention to these rules in a legislative body could be a good way, you know, is one thing that we need to have as part of thinking about our orientation towards the rules. What principles should we be using to make these choices? And bringing more people onto rulemaking committees who, you know, who haven't traditionally been on those committees, I think would be really interesting. And seeking out different voices to hear from is part of the project as well. So it's not, you know, just a judicial thing at all. I think it's very multifaceted.
Julia, your work, you've asked us, and your work helps expose the norms in the law of evidence and asks us to be clear about our norms and how we might help redirect the law. But there's also, in your example, something so profoundly humanizing about your work. And it's really beautiful to listen to you bring that humanity to what you're doing. So, and I think with that, we'll have a little time for some wine and cheese. Thank you. Thank you.